production.
Alright guys, I hope that you can see me. As I said before, today's vlog is really about depositions and what is a deposition, and specifically, what do you need to do as the client to prepare for a deposition. So to make things easier, I've already written everything, wrote everything up on the board for us to go over. If you can see it, I don't know if you can see it or not because of the way the screen is on my camera. I can't really tell if it's clear. I can't tell if I'm clear, but we're going to go ahead and proceed anyways. So basically, the scope of depositions here in the state of Texas is governed by the Texas Rules of Civil Procedure, Rule 192. That's not really something that you need to know, but I figured that I would start off with at least addressing that. There are a lot of other rules that interact with that one in particular, but that one just deals with the scope of a deposition when it's taken. Now, really, what is a deposition? Well, a deposition is basically out-of-court testimony that's sworn to that can be used in court, basically against you. So you have to be very careful about the things that you say when you're being deposed by opposing counsel, because the things that you say in that deposition on February 4th, 2013 can be used against you on February 14th, 2020. I mean, if there was a case that actually went that far, the opposing counsel could bring those statements back in to court and say, well, hey, you said this on this date that the bus actually ran the light, not my client. So you have to be very careful about that. So that's why I'm making this video for future clients to kind of just look over. So the purpose of a deposition is to elicit and preserve testimony before trial. Like I said, a deposition is to elicit. That means, to bring about, to bring out, to gather, to get, to get something. And preserve it. Preserve that testimony. Like I said, you could go back into the courtroom, 2 years later after a deposition is taken, and that deposition that you took at the time and the words that you said at the time could have have a large amount of significance on your case if they go against the things that you then say on the stand in the courtroom. Like I said, I don't know if this is dark enough or if I'm light enough because I look really dark on the screen. I know I've been out in the sun, but I didn't think I was that dark. But it's all good. Anyways, when you're in a deposition, normally there's going to be a stenographer. That's kind of the court reporter, the person who's going to be taking everything you say down word for word. And sometimes there's a videographer, someone who is there actually setting up the video cameras and has a camcorder or a camera or something in front of you, and you're being live taped. And that too can be played back in a courtroom when it's time for trial. There are a number of reasons why they do these things, but I'm going to get into that a little later. I want to keep going down my list. When we go in and we have a deposition, generally there are three types of objections that are made by your attorney in the deposition, or the attorney who's not taking the deposition usually has three types of objections. And they are objection leading, objection form, objection non-responsive. There's also another objection, a stopwatch objection, if you go over the time. Basically, you don't really necessarily need to know what all these mean, but basically, I will break it down for you to a certain extent. Objection leading is if the opposing counsel is saying something where they're trying to get some type of desired effect. They are attempting to push you down a path with with a sentence or a question that already has an answer that can only be answered almost in one way, and will abuse or make you look bad in the transcripts. That's probably the best way to say it, for lay people to understand it. But objection form, there are a number of reasons why you could say objection form. It could be a compound sentence, a compound question. It could be argumentative. It could be a number of different things. It could be speculative. The question that the opposing counsel asked you. So, and the last one is objection non-responsive. That's if you are in a deposition and you basically, if I can't even think of an example, but it's if you pretty much say something that does not answer the question that was asked of you. If the guy asks you or the lady asks you, so was it a black cat that walked across the street right before, you were hit by the car, and you say, well, it sure was sunny outside that day, or the light was whatever. You just say something that's totally random, that's non-responsive. So another thing that you may be wondering is how long can you be deposed? Because a lot of people tend to worry, oh my God, I've never had a deposition, I don't know what to do. Well, the short order is that for state court in Texas, excluding breaks, the maximum amount of time that you can be deposed is 6 hours. That's a long time. Federal court is 7 hours. That's a long time. So, make sure to take breaks. You can ask for as many breaks as you need. So sometimes this may not happen. Usually this won't happen with car accident attorneys or the opposing counsel, because the insurance companies, they have enough money to just do whatever they want to do and just throw money at the wall. So they usually will always have a court reporter, a stenographer, and they may have a videographer there as well. But for plaintiff's attorneys, I don't think any plaintiff's attorneys will be watching this, but a quick tip for some people is that you can actually work as the notary public. If you're a notary public, you don't necessarily have to have a stenographer there at the time of doing the depo. You just have to swear the person in, and you're going to have to get the record, transcribed or whatnot from the video that you shoot. So that's just a little tidbit that I would throw out there. But another thing, and like I said, this is kind of off topic, but I just thought that it would be something good to know, because people always ask questions about how is this going to be paid for, how do I have to pay for this, do I have to pay for that. The thing about it is the attorney who asked the first question in a deposition, it doesn't matter necessarily who was the deponent or who sent out everything first. The person who asked the first question at the time of the deposition is the person or the attorney or the firm who's supposed to pay for the cost of taking the deposition. So, like I said, I'm walking in and out of the screen right here. I hope that you can see me. I hope you can see all this. You probably can't, but I think I'm speaking loud enough so that you can grasp what I'm saying. The other thing that I wanted to talk about very briefly, because what I'm talking about right now, what I'm speaking about right now is I'm talking about just the average normal depo. When you come into a conference room, you sit at one edge of the table, there's a stenographer, there's the opposing counsel, here's me sitting with you. I'm talking about that type of deposition, or an oral deposition. But sometimes depositions are done by written questions. And in those situations, if I ever send a deposition to you that's written questions, what you need to do is you can have it signed in front of or filled out, agreed to in front of these 4 people: a clerk of the district court, a judge or clerk of the county court. That's a judge or the clerk of the county court, a court reporter, or a notary public. Usually the easiest thing for most people to do is just get a notary public to sign off on it after they fill out the questions or whatnot. I've had to deal with some depots by written questions, and usually they just get a notary public, so it shouldn't be that big of an issue for you. Usually you can take these types of things to your bank, and they'll have a notary public there if you're unfamiliar with where to find one. So that's just something to keep in the back of your mind. the main two things that I want to really kind of get to now is the what what should you be doing for a depo, and the why is this happening? Why is this deposition happening? So chances are, if you've come to me and I'm representing you, or I'm in your case somehow, it's probably a personal injury case. It's probably a car accident. It's probably a truck accident. It's probably a Jones Act case. It's probably a railroad case. It's probably a dog bite case. It's probably some type of personal injury case, but more than likely either a car or a truck accident. But it can be a variety of things. But what I need you to understand is why this deposition is happening, because a lot of people, they get injured, they come over here to my office, and they say, well, this guy rear-ended me. He should be paying my bills. He should be giving me something for all the injuries and the pain that I'm going through. And it's understandable that people feel that way, because here you are, you're just minding your business. Someone comes along being careless or negligent or intentional and hurting you, and you have nothing to show for it but pain and suffering. And a lot of people can't seem to wrap their minds around that. Insurance companies can't seem to wrap their minds around that. But the thing about it is that in order to receive compensation for your injuries and care for your injuries, you have to show damages. And when we're talking about damages and we look at how a deposition plays into all this, what we are really seeing is that the reasons why, I think, these are my reasons, the top 3 reasons why depositions happen in personal injury cases is, number 1, the opposing counsel and the defendant want to hear your truth. Now, they may say your story, but I'm going to say it's your truth because it is your truth. If you're the person that's injured and you were injured by the carelessness or the negligence of someone else, clearly it's your truth. You are standing in your truth. Anything that they would say beyond that is falsehood. So they want to hear your truth. They want to know your story. Why does the opposing counsel for the insurance company, why does the defendant corporation want to know your truth? Because they want to try to poke holes in it. So when you go into a deposition and you understand this from the very beginning, you have to be very careful about the things that you say. And if you aren't careful, someone can try to paint the thing that you're saying in a way that is completely false. So that's something to be aware of. Like I said, number 1 is the opposing counsel and defendant want to hear your truth so they can poke holes in it. The second thing is that opposing counsel wants to evaluate how a jury will perceive you. Now, you remember that I told you that usually there's a stenographer, which is the court reporter that types everything up, and you have the videographer who will also come and they will shoot the video of you. And they do this because it's not just because of the fact that they want to take that video and put it in a courtroom for someone to see. What they want to do is they want to take it back and they want to look at it and say, well, Susan, she really carried herself very well, and she carried herself very well, during this deposition. I think that a jury might be a bit more sympathetic to her than we initially thought. And so, with that type of case, when that type of situation comes around, then obviously that means that your case's value has been enhanced when you know how to carry yourself well. If you're coming in there and you're cursing, you're fighting with the lawyer, it looks bad on you, not just me, because if obviously it would look bad on me because that would mean that I hadn't prepared you properly for what you were about to step into as your attorney. But I would think so at that time. But you have to understand that you don't want to present yourself in a negative light with them, because that won't work out to your benefit in any way, shape, form, or fashion. Even if you are, hurry up and just pay my medical bills. Even if you feel that way, you can't be that way with them, because a shark can always smell blood in water. I don't know if they really can, but that's a good saying, And that's what holds true to this particular situation. When you're desperate, insurance companies, for some reason, they they know how to pounce on it, because obviously, you know, that helps their bottom line if they can resolve cases for pennies on the dollar. So, you know, you always want to deal with your attorney and just listen to what they're trying to tell you. So, like I said, number 2 was the opposing counsel wants to evaluate how a jury will perceive you. So, like I said, how you come in and how you present yourself in front of them, because you got to remember, a deposition is out of court testimony. It's sworn testimony that can still be used against you in a courtroom. So you have to carry yourself with a certain type of majesticness. Is that a word? I don't know. You know what I mean, though. Number 3, both parties can evaluate the strengths and weaknesses of the case and each other's. Okay? I'm sorry. Both parties can evaluate the strengths and weaknesses of the case and either settle or proceed to trial. The good thing about depositions, even though they can be somewhat costly and burdensome for everyone involved, and the time it takes to do all this, it does help to somewhat flesh out a case, because you may have knowledge or you may have evidence that they weren't aware of, you know, and when that comes about, when they maybe uncover your truth versus their client's falsehoods, that may make them change their viewpoints on how to properly evaluate this case. So, like I said, the 3 reasons why I believe that depositions occur is that, number 1, opposing counsel and defendant want to hear your truth. Number 2, opposing counsel wants to evaluate how a jury will perceive you. And number 3, both parties can evaluate the strengths and weaknesses of the case and either A, settle the case, or B, proceed to trial. All right. The last thing I kind of want to get into, I just completely stepped off screen right there. I feel like Superman. Oh, I'm Superman. Hey, all right. But the last thing I want to talk about before I leave, and let's see. Yeah, I'm doing pretty good. Okay, the last thing is the what when it comes to the deposition. Like, you know, what do you need to do? What do I do? Because that's what everyone wants to know as a client when they are dealing with a deposition. That's what everyone, you know, hey, oh my God, I've never dealt with a deposition before, or maybe I have dealt with a deposition, but it's been a long time ago. What should I do? How should I prepare? Get me ready to go in there, you know, to do my best. Okay, and this is what you need to do, okay? So we're going to go down this one real kind of slowly. The number 1 thing that you need to do when it comes to a deposition is you need to tell the truth. Don't try to hide anything. Don't try to cover anything up. Don't try to say, yeah, but, you know, I don't know. I mean, how's that going to look? Don't try to out-lawyer the lawyer. And what I mean by that is, if your lawyer is telling you, tell the truth. Go in there and tell the truth. Because that's what's going to work to your benefit in a deposition. Don't go in there and say, well, hey, you know, I thought that if I said that, then he might say this and then that. If you do that, you're going to destroy your case. Tell the truth. You have nothing to hide, and put the facts on the table, because as I said before, when we're dealing with these types of cases and you are a plaintiff, you are here to receive your care and compensation for the truths that you've had to live. So if you've been injured by someone else and that's your truth and they owe you damages, tell your truth and leave it as that. Don't try to add more to it. Don't try to jazz it up. Don't do any of that. Tell the truth. Okay? That's number 1. Number 2, dress appropriately. Okay? Perception is everything. Well, that's what they tell me. I still wear a hat backwards and everything, and I'm a lawyer. I don't shave all the time, so I don't know. But I do know that when I go into the courtroom and it's time for trial, and there are 12 people in front of me that are going to judge me, and they don't know me, I'm going to present myself in a certain manner, because that is what is most effective for my clients. Now, it's one thing to come out here and have fun and joke around and make little vlogs and everything like that, and make them informative, and that's fine. But we do all know that the first perception that we have of people, usually, whether it's wrong or right, is the one that we mosey on, we carry on, we believe that one, we hold on to it. even if it's not true, even if we see things, much further out that show us, hey, I was wrong about that guy, I was wrong about that girl. We still want to hold on to those things. So when you're in a deposition, you have to understand that you're only going to get one chance to make that first impression. So if there's a videographer in here and they're recording you, it doesn't matter if you wear Neiman Marcus all the other days, but you come in here today and you just look like you stepped out of a garbage bag, or you just woke up next to the Cookie Monster or something. It's not going to matter, because that one impression that you have is going to set the tone potentially for the rest of your case. So always dress appropriately. And when I say dress appropriately, I can't make it any more simpler than saying, hey, if you were to go to church, how would you dress there? And if your church is that relaxed and you don't wear ties or you don't wear anything like that, then how would you dress if you had to go to a funeral? How would you dress if you had to go to a good job interview? Those are the types of things to consider. And so the number 3 thing is to remain calm. That's like, you got to remain calm, because in any situation, remaining calm is perhaps the best thing that you can do, simply because it's going to allow you to properly think everything out. If you're rushed, if you're anxious, you're not going to do very well. You're not going to be able to really focus on the questions at hand. You're going to be focusing too much on your emotions and the adrenaline and the hormones and everything else that's pumping through your body. So, if you need some tea, if you need some water by your hand, if you need you a little squishy or something like that to bring with you, whatever you need, you let me know before we go in there, and I'll make sure we get it for you, okay? Because remaining calm is perhaps one of the biggest things, if not, well, it is one of the biggest things. That's why I put it number 3. But remain calm, okay? So number 4, listen to each question. Listen to each question. Listen to each question. What I mean by that is that you cannot put more into these answers than what you are being asked. If the opposing counsel, if the insurance defense counsel's lawyer asks you, did you drive down this street and then make a right? And if you drove down that street and you made a right, yes, I did drive down the street and make a right. Right there, wherever he said the road is. And that's all you say. You don't say, I drove down the street, I made that right there, then I made a left, I turned around, I busted a U-turn, I came back, I thought I forgot something at the house, I had to come back and get it, I made another left, and then my daughter called me, and then my husband called me, and no, see, you're doing too much. You're doing too much. Answer the question. Listen to each question that is being asked and give no more or say no more. Because sometimes you open up yourself to allow them to take you away from the truth. And that's what you want to remain in, is your truth. See, when you allow them to cloud the crystal ball, in a sense, you're going to be knocked out the box, because that lawyer is going to be a smart attorney, and they're going to take that extra thing you said and they're going to run with that, and they're going to try to make the case about that extra thing and not about the truth of what happened and how you were injured. So listen to each question. Number 5 follows right behind that. Answer exactly what you were asked. Okay? Nothing more, nothing less. You don't have to go in here and try to explain the way the world, none of us are God. We don't have to try to explain the way the world. You don't have to do all that. Just answer exactly what you're asked. Okay? Number 6. Remain courteous. Courtesy in today's society, for whatever reason, is a lost art. Civility is a lost art. But that's something that we can all practice. And in this type of situation, I would say that most opposing counsel are not bad people. They just have jobs to do. and so they're there to do a job. But a lot of times, if people can see that you're reasonably, they can see that you're hurt. No one is. I would hope that no one would go out of their way to try to deny you what you're due in those types of situations. And if they do try to do that, then they're gonna see another side. But anyways, remain courteous. You always remain courteous. If anyone ever needs to get out of line when it comes to your case, it should be the attorney. It should not be you. Okay? You remain courteous. Don't get your blood pressure up. Number 7 is take a break or two if needed. So I told you before that they can have you in these conference rooms for 6 hours for a state case, district court case. And that's a long time. So federal court is 7 hours. So if you need to take a break, if you got a small bladder, weak bladder, whatever have you, you ate something that don't agree with you, you're lactose intolerant, you need to go to the restroom, you go. You go. Don't be intimidated by this process. These are people who just understand some rules a little bit better than you. That's what we went to school for. We understand some rules. That's all it is. These people aren't any better than you or anyone else. Okay? We all are the same. We all are God's creatures. It's just this is our job to help you in this particular situation. So I'm going to go back down these real quickly. Number 1 is tell the truth. Number 2 is dress appropriately. Number 3 is remain calm. Number 4 is listen to each question. Number 5 is answer exactly what you were asked. 6 is remain courteous. 7 is take a break or two if needed. And the $1 million question that everyone always wants to know at the end of a deposition, Mr. Alexander, how long will it take for my case to settle now that my deposition is over with? And the answer to that, sorry, it depends. There's really no way that an attorney can completely give you an absolute deadline or timestamp of when your case is going to settle. Hey, at this point, due to all the stuff with Hurricane Harvey, we can't even tell you exactly when your case will go to trial because the courts are so backed up to a certain extent. So with a case like, well, I can't say with a case like this, but with a case where you have a deposition, if there aren't other depositions, and it depends on what's going on between you and the opposing counsel. If you guys are, if your case is already a case where both sides are seeing eye to eye, your case may settle in a week. It may settle in 2 weeks. It may settle in 3 weeks. It may settle in 2 days. But if you're still far apart, or they feel like, oh, well, she said some things or did some things in the deposition that we kind of thought were, a little iffy, then that might change the scenario. Usually, though, after depositions, cases will settle at some point. I read something a while ago that said about 85% of cases actually settle. So I don't know if that's necessarily true, or if that's a high number or a low number, but a large number of cases do settle these days, simply because you can just look at the civil trial system and how it's set up. So I think that is everything. I'm pretty sure that this wasn't really as clear as it could have been, but my goal is just to illuminate you, to give you some knowledge about, what happens in a deposition versus just kind of sending you in there blind. Or maybe this will help someone who is going through a similar situation. So with that said, I hope that this has been informative for you. I hope this has helped someone out there with what you need to know about a deposition, what is a deposition, and what you need to do to prepare for a deposition from a client's perspective. This is the Texas Big Rig Bull truck accident lawyer. Sorry, I messed up. I hope that this has been informative to maybe future clients of mine, but also people around the state of Texas that have cases like this, or maybe are in this type of situation. I think that's it. I think I've pretty much addressed everything. And as I said before, this is what is a deposition and what you need to know to prepare for a deposition from a client's perspective. This is the Big Rig Bull, Texas truck accident lawyer Reshard Alexander. See y'all later on the next vlog.
Ryan Little.
Wow. I am like so unbelievably tired right now. It is not even funny. So, yesterday was the beginning of my vlog series, or the rekindling of my vlog. And I have some ideas about what I want to do with this thing and how I'm going to try to involve people in it. But yesterday was a really good start for me because I knew that I wanted to do something that was bigger than me. And Memorial Day and Houston National Cemetery was an excellent opportunity to do so. But you snap away from that time and you come back, and now you're back in work, or now you're back in the office. It's not vacation time anymore. You actually have to make this stuff happen at the same time that you manage all your casework. And so, no lie, last night I stayed up until 4:30, 5 o'clock, 4:30 a.m. or 5 a.m., one of the others, just so that I could make sure I completed my vlog, because I was like, I'm gonna do this, I'm gonna do this, I'm gonna do this. And I had to go to court. I had to be in court at 9 a.m. this morning. So I'm kind of a little tired, but it's going to be all good. The thing about it is that it's always hardest first when you're trying to do things like this. I know it is, because you have to break down the process of learning how to do things quicker and quicker and quicker and quicker. And so that's where I am right now. I'm right at that point where it's like it's going to take a long time to do these vlogs when it comes to the editing portion of it. And that's fine. I'll go ahead and push ahead anyways, because I thought about giving, that portion of my vlog away. But, the thing about vlogging is that your personal edit is really what makes it special. I mean, you could try to have someone do a vlog for you or whatnot, and it won't really come across authentic. I've watched other attorneys, business people, or whatever, try to do vlogs, and you can tell when it's like something they've created versus something that they've had someone who professionally does this all the time, regulate their stuff. But for me, I'm just doing my own thing.